Our last item, Commissioner Grieco. What is it? R9?
It's R9K.
R9K. Okay.
It's CIBO Restaurant Project located on South Point Drive.
Commissioner Grieco?
Thank you, Mr. Mayor. I placed this item on calendar as this is in the top 2 matters that I get the most emails about. As most know, I live south of 5th. I used to live at one of the adjacent buildings to a project that's been going on, I guess, since the 90s, and it's starting to seemingly come to fruition. And there's a lot of folks that live near or around what is being constructed on the corner of South Point Drive and Ocean Drive, which is right at the entrance of the Continuum and also adjacent to the Portofino Towers and South Point Towers. And for those that are not informed, just very briefly, even for my fellow commissioners, there is a relatively large restaurant with rooftop operations, and it's going to have a huge impact on the area. And a lot of residents of those buildings have expressed concerns. But the main reason I placed this on is so we can have a brief, open, public discussion about the facts, about what the city can and cannot do, and what the city has already done, and what the city intends to do. Because I've received a lot of emails that are seemingly based upon bad information, and I want to make sure that we're all on the same page. I personally, as somebody who lives down there, and I also formerly on the board of directors for the South of 5th Neighborhood Association, I personally did a walkthrough with the attorney for one or more of the condo associations. I've been in constant contact with the city administration as to what's been done, and I also welcome Joe Jimenez from the administration as well, and our city attorney, and we're going to allow for a few comments from the folks that are affected, but most importantly, I'm going to ask Joe to kind of give us a little bit of background as to what's been done, what's being done, and a lot of the issues that have been brought up regarding the rooftop operations, the valet operations, garbage operations, things like that, and some of the concessions that have been made. And just so people know, I'm going to actually pull a copy of this tape of this hearing, and I'm going to put it online, and I'm going to make it available to every single person that lives in every one of these buildings, so everybody is informed as to what is going on. So, you know, regardless as to what the end result is, we are doing everything within our power because the residents come first, and quality of life comes first. And there are a lot of rules that have been passed south of 5th subsequent to this building permit being issued that were consistent with us trying to have it be a quiet neighborhood, have it be a low-impact neighborhood, no rooftop operations. But this has been going on for a long time. So, Joe, I defer to you.
Thank you, Commissioner. Joe Jimenez, Assistant City Manager. I was just thinking, I started here on June 3rd, which was a Monday, and that Thursday, I went to a South of 5th Neighborhood Association meeting where Victor actually gave me their complaints on a board. And I still have it in my office. If anybody doesn't believe me, they can go up right now. And on that was this restaurant. So I've been living with this, monitoring this since I started here. The information that has been put out sometimes I don't think has been clear in that the city, prior to the vast majority of the people on this dais, and certainly myself, entered into a settlement agreement with this property owner which vested them in certain development rights. The emails that I get constantly, and I welcome them, and I want to know what people are thinking, seem to imply that the city is going to pass on some sort of application for this use. And that's simply the way things stand right now, just isn't the case. The building, the shell permit was issued. I think the original permit was pulled in 2007. With me also are Tom Mooney, the acting planning director, Eric Carpenter, the public works director, and Gary Held, the assistant city attorney, because there'll be pieces of this that everybody just knows a little bit better than I do. But if the original permit was pulled in 2007, there were certain regulations that were not in place yet governing the use of South of 5th rooftops, which at the moment limited to 40 seats no later than 8 p.m. The building plans that were submitted for this property showed in excess of 100 and, upstairs? Yeah, 300 seats total, and upstairs, well over the number, let's put it that way. 400 on the 400 total and 137 on the roof, I think it is? 73. I've got them mixed up. So more than 170, I think, is a consensus by. And those were shown on the plans. They were vested in that use. They showed it on the plan.
Explain why they were vested. Can you try to give as much detail
Absolutely,
so I understand? Why were they vested? Why was there a settlement? What was the dispute? Just so I...
That, if you don't mind, Commissioner, I'm going to leave that to the city attorney's office, which if you want the answer now, they can give it to you.
Let's keep going.
Yeah, but that's precisely what I want to do.
Gary, why don't you stand up there with them and you guys can play Mutt and Jeff and give me the... So I understand.
Jeff, and he's mine.
I can't
All right.
be the city attorney.
So what was the dispute? There was a dispute and there was a settlement agreement. What was the dispute?
So,
Sorry, do you mind if I ask?
no, go right ahead.
All right.
Gary Held, City
our last
Attorney's
item.
Office. Actually, the agreement itself lays out the dispute. There was an original development agreement back in 1984 that governed development of what was then called the Chisholm parcel. It's the South Point parcel on which Continuum now sits. In 1997, city attorney at that time, Murray Dubbin, had determined that development agreement had expired.
Was it city property? Was it city-owned
No,
land?
private development.
So then the development agreement was between who and why?
It was to guarantee, to confirm development rights, long-term development. It could have been a phased development. There were a lot of
But it was a development agreement with the parties being who? Was one of them the city or?
city and South Point Development Company.
But it was not city-owned land.
It was not.
So then why was the city a partner in a development?
Because we're granting, that's statutory.
That's what?
That's statutory.
It's used for large-scale developments to confirm development rights over a long period of time.
Okay. It's statutory.
Okay.
So there's a
So-
development agreement.
In 1997, I believe it was Murray Dubbin at the time, opined that the 1984 development agreement had terminated. That resulted in the developer initiating legal action to confirm his rights, to establish his rights in the ongoing status of that development agreement. And in 1999, that litigation, among other litigations, including a Burt Harris claim, resulted in this settlement agreement, an amended and restated Ocean Parcel Development Agreement dated March 5th, 1999. The operative paragraph in that development agreement, the 1999 development agreement, and I have copies of the first page and that particular page for the commission, is that certain development rights governing, there's a litany, development, density, permitted uses, growth management, environmental considerations, design criteria, and other matters pertaining to development shall be those in force and effect on October 9th, 1984. So essentially, we were agreeing in 1999 that the 1984 code applied.
Okay.
And for the record, that is Section 7 of the development
So
agreement.
basically, the dispute is that somebody at a city attorney had entered an opinion that because they hadn't done anything, that their rights had disappeared, and then they sued, and then there was a settlement agreement saying that, okay, fine, you have whatever your rights were in 1984.
Correct.
That's where we are.
So,
And that brings us all the way to today's date, and the city attorney's office is telling us that the code that applies to this development would be 1984?
For the most part, yes. That's how Continuum 1 was built. That's actually how Continuum 2 is built and why it looks that way. They never had to go to DRB. They built according to the original plan, or else that they probably would have been challenged in court. And that's how the building permit for this property was built. It was probably part of an original development plan.
Who owns this and who's the developer?
Now I think it's related. Eichner is the name that I know.
I'm sorry, who?
Eichner is the name that I know. They are represented today by council. If you have...
Where's the exact location of the parcel?
What?
it's right at the entrance to the Continuum. It's just to the west. It's the west entrance of the Continuum.
Okay.
On the south side of South Point Drive. So I guess I just want to on the south side of South Point Drive.
Commissioner Grieco, why don't you-
Here's Gary. Here's my question. Can we, as a city, tell this restaurant when they can operate on their roof? What can we tell them to do? What can't we tell them to do? What can we do to protect the residents is my main question.
And the other part of that question is, what can we do to regulate alcohol service? Because I believe there's some control over that. For the hours I'm talking about.
Okay, so I know a number of these issues were going to be part of Joe's presentation. I'm not sure how
Knock
much.
yourself out. Go ahead. When they have a question
just
for me,
wanna-
I think they'll.
So our interpretation of the development agreement of 1999 is that those issues that are part of the litany of what I listed are those that are protected under the 1984 code. So, for example.
Can you say that another way? I didn't make any sense.
I kind of want specifics.
Yeah, just
when
be-
it comes,
be-
when it
just
comes
be
to
clear,
what can,
man.
what can we stop them from doing
yeah.
earlier?
And to answer the second part of your question first, because I think it is important for everyone to be made aware of what we've done, instead of, because I think what we're saying here is what we can't do, and there is a lot that I believe we have accomplished, working together with the homeowners associations. Both of which were represented by council. We've met with them at least 3 separate occasions that I can remember, and Tom Mooney and I have also spoken to the operator. The operator has agreed to, and I gladly invite, I know Victor's here, and Victor and I have spoken about this. The deliveries are taking place in the back. The driveway is not being impacted.
Can you answer his question? I'm sorry.
But what we've done,
sorry.
what we have done, what they have asked for, we have gotten with the homeowner association, and at the urging of this commission, and at the urging especially of Commissioner Grieco, who proudly claims, he's like, if I'm going to be the South and Fifth Commissioner, I'm the one that's going to go through this. And I've kept him abreast of this. We've gotten the driveway to not be impacted at all. The parking, that there was some debate as to whether or not the 30 spaces that they would have been required to have under the 84 code are not going to be used inside the Continuum parking garage for certain key personnel, like the general manager of the restaurant, the chef, people like that. But the general public will not be allowed to go in there, neither will the valet. The deliveries will take place the same place that the deliveries take place for the condominium. The trash pickup will take place around the back. So that driveway, which would probably, the pavers would not hold that load, that's a very valid concern, and that was moved around the back. The valet ramp that was originally the operator originally wanted it on the driveway, the Ocean Drive extension, is being brought around to South Point Drive. One mistake was made. I'm going to say it now. It was an error that's easily fixable, and we are in the process of fixing it. A right-of-way permit was erroneously given to the shell for an extension of what they called a valet ramp. No valet operational plan has ever been approved. And those emails that went around about a month ago calling me a liar, they were incorrect, because I was wrong about the valet permit, that it was some right-of-way permit. Saul Francis never saw it, Tom Mooney never saw it, I never saw it. I don't care what they are able to do there. We have never approved a valet operational plan for this restaurant. One is not approved today.
Okay.
And we're fixing that curb cut that was erroneously done.
Great.
So that part, I'm happy to admit to the mistake, but it was.
Can I just ask everybody a question, because Commissioner Grieco, I'm not sure. So what is everybody here for? What's
And
the problem?
as I started to say, whatever,
We're there. We're getting-
whoever is giving them, whoever is giving the residents information, judging from the email that I'm
Right.
getting, and I'm sure you all are getting,
Got it.
it implies that this restaurant's coming in for some sort of application and urging us to deny it.
Got it.
There is no application pending on uses.
Right.
There's building permit, and we'll inspect it according to the building code, but not the zoning code.
But is it because they're allowed to have a restaurant there? Is that what you're saying? I mean, Commissioner Grieco's initial question to Gary Held his first question was, what are we allowed to tell them not to do? And you stepped in and said, listen, we've gotten some concessions, even though they're allowed to do things, we've succeeded in getting them not to do certain things. And we appreciate that. That's a tremendous benefit. But if you could answer the legal question, please, Mr. Held, so I understand what we're dealing with.
Okay, so there's 2 bases upon which they are entitled to have a restaurant, and they are protected from further regulation.
Okay.
The 2 bases are this 1999 development agreement and the equitable estoppel ordinance in the city code. So they received a building permit on June 27, 2007. The ordinance that deals with rooftop or above-ground deck activities was adopted in 2009. So they are protected from enforcement of that ordinance.
Okay, so basically, there's,
So
other than what Mr. Joe here has told us he's been able to achieve, there's nothing else that we can do.
well,
And I think Commissioner Malikoff, she's still.
there are a number of issues.
All right,
That was
let-
just the first
okay,
issue. That was just
Commissioner
the use
Malikoff.
of the deck.
Got it.
I would like to go further with the use of the deck, please. I think that's one of the most contentious,
Yeah.
and it's going to
Right.
impact the neighborhood the most. Now that we understand that the valet has never been approved yet, it's going to be changed, the trash is going to be in the back, deliveries in the back,
Okay.
the driveway is free, those are all great, because those were some of the
You raised the
comments.
question of hours of-
Rooftop, hours,
Right.
no
So
entertainment, no loudspeakers, all of that we need to hear from you,
So
please.
the planning director, acting planning director, or the planning director at the time of issuance of the building permit was presented with a set of plans that showed a certain number of uses on the roof. Those uses, we've determined, are grandfathered as of that date. So I don't know how many seats, what, is it 140 seats on the roof?
170.
And the planning director has imposed, and the operator has agreed not to have speakers on the roof. So music on the roof should not be an issue. There will be background music allowed in the establishment indoors itself. Background music means at a level that does not interfere with normal conversation. It should not create a noise issue. It's not entertainment.
And it's important to note that regardless of what any of this says, the noise ordinance still does apply.
Right.
Nobody
Right.
gets grandfathered into violating that.
Sure, so just to
It's
make.
never any consolation to them, though. I
No,
mean,
it's
Just-
just
just-
what I-
nah,
then we
they
gotta
know,
pass
they
it.
all know
So I
how
wanna-
that goes.
Let's go.
Just
Sorry.
to make this clear, based upon the settlement agreement and based upon the plans that were submitted in 2007, we are legally prevented, as a city, as an administration, we are prevented from saying, hey, you have to close your roof at midnight or 2 o'clock. Like, they can stay open if they want to on the roof with their 177 tables, serving food and drinks until 5 a.m. if they wanted to. Is that an accurate statement?
I believe that the ordinance as adopted in 2009.
Just tell us yes or no.
Yeah, but he's carrying, like, give him a chance, Johnny. He's trying to spit it out.
I know, but
The ordinance as adopted in 2009, we cannot enforce that ordinance against them. And that's the one that enforces the South of Fifth regulations on rooftop hours and operation.
you mean 09?
But that.
I'm sorry,
Did
but-
that give them a 5 a.m. closing?
They
I
have
don't
not
think
yet
so.
applied for, nor have they received an alcohol beverage license. However, there is no restriction in the code that prohibits them from getting an alcohol license to 5 a.m. There is a BTR provision. We discussed this yesterday. I met with the planning director and ACM. It's a ministerial act, once they get approval from the state for an alcohol beverage license, to either get a 2 a.m. license or a 5 a.m. license.
We
do
can't
not
prevent
have-
them from getting a 5 a.m. license?
Typically, that is something that is done when they go to a land use board hearing. There are no land use board hearings that are necessary for this establishment.
So we cannot, if they ask for a 5 a.m. liquor license, there's nothing that this city or they can do to stop that.
It's
Is that
not a
correct?
request.
Can I just understand? Is that correct?
It's not a request, but
Gary.
not that they're asking for a 5 a.m., it's a BTR.
I'm sorry.
They just
So
I still feel like you
So
didn't just clearly
there's-
answer Michael's
okay.
question.
There's an argument that can be made that within the scope of the development agreement, there are some openings. One of those openings is a concept that deals with operating conditions for legal nonconforming uses. It's not, they've identified permitted uses, but they haven't identified operations as part of all of that they are protected
Okay.
from. We would have to adopt a citywide ordinance for them, to enforce this against them, not,
Explain, so that's,
if
we
we
would have to adopt a citywide ordinance that deals with legal nonconforming uses and how they operate?
yes, something like that.
That sounds
Wouldn't it be
like, that
just for
sounds,
south of
the only thing I'd say
neighborhood?
about that is if something has a legal nonconforming use, are you saying then to restrict how legal nonconforming uses operate that applies to all legal nonconforming uses?
I think so, yes.
Could that run afoul of the fact that they are legal nonconforming uses?
No, as long as we don't eliminate the use, we might have an opportunity to regulate it. We did it before with juice bars that were previously in existence. We required them to go for conditional use. It's a controversial procedure and not fully developed at this point.
Mr. Held?
Ma'am.
The south of Fifth neighborhood has certain restrictions for the south of Fifth neighborhood where this is located.
Correct.
Is that correct?
Yes.
Instead of doing a citywide ordinance, can't it just be for the south of Fifth neighborhood as part of the
There are other
restrictions in that neighborhood?
There are other provisions of the development agreement that talk about this being, any modified rules, regulations would have to be citywide. So that's the way I read it.
Okay. Can we hear from someone else? Just, I think it's important.
Happy to read.
I love to,
What were you?
Jonah?
No, it's fine.
I want to hear from former Commissioner Diaz, who has a lot of paper with him. And he is building up his bicep by holding that, and I think it's only right for us to let him put it down, so he can say a few minutes.
I will.
I think this gentleman, right, I think, definitely. Okay. Joyce, let's let, Victor, because I think
First
Victor
of
has a
all,
great
Victor
understanding.
Diaz, 100 South Point Drive, apartment 3705. I appear here today as the president of the Continuum Master Association, as well as the president of the Continuum South Tower Condominium Association. I want to first thank Commissioner Grieco for putting this item on the agenda to help both educate the City Commission and the community about the issues of concern to the residents south of Fifth, as well as the mayor for granting us this time certain, especially today that we have a fire drill. So we appreciate both of you doing that. Since March of last year, when I first was elected to the Board of Directors and the construction of the CIBO restaurant began, we have been engaged in a constructive dialogue with both the developer, which is South Beach Ocean Parcel Limited 2, an assignee of the original developer under the development agreement, and the operator, Liberty Entertainment Group, which is represented by Mr. Nick DiDonato here. I have had dinner with Mr. Nick DiDonato. I have met with him on 2 or 3 occasions. We have expressed since that time a number of concerns, some of which are no longer of concern anymore. And we don't need to dwell on that. We appreciate both Mr. Nick DiDonato's response to the neighborhood's concerns, and I want to publicly acknowledge that with respect to the issue of, and we think we had a right to enforce those restrictions, but he didn't fight us, with respect to the garbage refuse delivery, he has agreed to do it at our loading docks. With respect to the size of trucks that will be going up our entrance driveway, he has agreed to the restriction that applies to all other commercial uses and residential uses in the building. And with respect to service deliveries, he has agreed to do them at our loading docks, which applies to all other commercial and residential uses. So we are glad that he is abiding by the same rules that our other commercial tenants are. And we appreciate his acknowledging those in a letter that he sent to the Commission. We also appreciate that the zoning director has indicated to us, and that he has indicated to us in writing to the City Commission, that he does not plan to have an entertainment establishment at this restaurant, and that once the building code, once the permit is granted, the development agreement will be terminated, and the zoning that is currently in place south of Fifth, which prohibits entertainment establishments south of Fifth, will prohibit to future uses of this parcel should the CIBO restaurant not be successful. I want to be clear that it is the intent, it is the desire of our residents that CIBO succeed, but that it succeed in a manner that does not interfere with the quality of life of our residents. There are 2 issues that are of continuing concern to our residents. One is the city will have to pass on a valet application for the ramp for this restaurant. It is a ramp operation that will be done at an administrative level by your parking director, supervised by your assistant city manager, and ultimately under the authority of your city manager. We have asked 5 things so that it is clear what we are asking of you to instruct the city administration. 1, that you carefully evaluate the parking, the valet parking study, traffic study that has been given to the city. We believe that it is flawed. We have hired our own traffic engineer. We have given a commentary on that. We can comment, and we're happy to talk to city staff further about misimpressions about the competing studies. But we have concerns about the fact that even their own traffic study indicates that in order to maintain free-flowing traffic on South Point Drive during peak hours, they would be required to maintain 15 ramp attendants. Second, we would ask the city to, as you have in other ramp operations, be conscious of the fact that sometimes off-duty police officers can be required in order to maintain one open lane of traffic. And I'd like to show you the configuration in a minute so you understand what critical concern this is to the residents of the Continuum and the adjoining buildings. Third, like you know, it exists all throughout South Beach. We would like the city to prohibit VIP ramp parking so that you won't see Bentleys and Rolls Royces occupying the ramp spaces that otherwise should be utilized to get cars off the street. Fourth, we would like the city to examine carefully the proposed circulation route for valet storage. Right now it calls for those cars to cross 2 active lanes of traffic within 200 feet and do either a left-hand turn onto Ocean Drive right in front of the entrance to our building or a U-turn on South Point Drive. And we've had dialogue with the city about how that would create an enormous amount of congestion during peak hours. And fifth, we have asked the city staff to verify the capacity of the proposed storage lots. We have been told by other business owners who operate major restaurants in the neighborhood that the very same lots that are being proposed by this operator to store their valet cars are already at full capacity, servicing the many other major commercial destination restaurants that we are lucky enough to have been built south of 5th. And let me just show you why the residents are so agitated.
Victor, can you use that mic?
First of all, we have been dialoguing with the city, as you have correctly noticed, in a constructive manner since June. The assistant city manager admitted it was an error. But the citizens get very agitated when they see concrete being poured, even though we have been assured that this ramp is illegal. You just heard it. It's there, it's physically there, but we now know it is illegal. It was built